Hello everyone, you're listening to The Progressive American, a news podcast from a progressive perspective. I'm your host, Connor Kelly. It is January 29th, 2022. We have a lot to cover today, including the death of voting rights protections in the Senate, the Supreme Court allowing Trump documents to go to the January 6th Commission, and Sarah Palin's lawsuit against the New York Times, to name a few. With that out of the way, let's get into the news. The Supreme Court rejected Trump's attempt to block the release of White House records concerning the January 6th attack on the Capitol last week. The decision was almost unanimous by the court, with only Justice Clarence Thomas in dissent. In their ruling, the court explained the case's importance, writing that the argument by Trump and his lawyers concerned circumstances in which a former president may obtain a court order preventing the disclosure of privileged records from his tenure in office. Previously, an appellate court had ruled that even if Trump had been reelected, his claim of executive privilege likely wouldn't have held up under judicial review. Upon examining the Court of Appeals decision, the Supreme Court argued that, quote, because the Court of Appeals concluded that President Trump's claims would have failed even if he were the incumbent, his status as a former president necessarily made no difference to the court's decision. In other words, Trump's argument that he can claim executive privilege would necessarily be easy to dismiss because he's not the current president. And even if he was, he would still be blocking an investigation that has great importance to the American public security and safety. As such, the court had no choice but to throw out Trump's argument. Not long thereafter, the National Archives, which holds presidential records, began handing over hundreds of pages worth of documents to the committee. Two of the committee's members, Representatives Benny Thompson and Liz Cheney, referred to the ruling as, quote, a victory for the rule of law and American democracy, unquote. Now, prior to this ruling, Trump's assertion of executive privilege was to some extent dependent upon whether or not the Biden administration would assert privilege over the materials. As previously noted, only the president really can claim executive privilege unless there is some sort of sensitive documentation from a previous administration. However, the Biden administration never actively put any such claim. In fact, the White House counsel Dana Remus wrote that, quote, Congress is examining an assault on our Constitution and democratic institutions provoked and fanned by those sworn to protect them, and the conduct under investigation extends far beyond typical deliberations concerning the proper discharge of the president's constitutional responsibilities, unquote. Meaning that the White House sees this as nothing more than an attempt by a former president to block an investigation into his neglect of our national security. And reading through this case, I can't help but agree with the White House counsel. The issue at hand does not fall within the typical way we handle executive privilege claims or the implied powers of Congress, especially when it comes to demanding records through a subpoena. If anything, executive privilege, which is not explicitly mentioned in the Constitution, should always yield in the face of an investigation like this. Remember, the House Select Committee on January 6th is investigating whether or not the former president was aware of the violence before it occurred and to what extent he neglected to defend the Capitol building once the rioting was underway. And the importance of that investigation is laid bare when you consider that Trump is trying to keep a lot hidden. He is attempting to block access to talking points that were written for his former press secretary Kayleigh McEnany, a drafted executive order concerning election integrity, and files from his former chief of staff Mark Meadows, all of which will be of great importance to understanding the frame of mind that the former president was in when he was dealing with the January 6th insurrection, an insurrection that was motivated by his lie that the 2020 election was stolen by President Joe Biden. And with that in mind, I think it is critical to remember that although Trump may not be prosecuted for what he did, that always remains a possibility. And more than that, exposing the depths of his allies' support for this illegal attempt to overturn an election is an imperative part of restoring our democracy. We can't have a society that allows the president and his allies to go unquestioned when something this extensive and violent occurs, much less before the midterms. And while I'm thankful that the court has allowed the commission to move forward, it'll be some time before we ever know just how much our president failed his nation. We need to keep pushing and pushing and pushing and get as much information from former President Trump and his allies unless we want this thing to go under the rug, never to be heard about again, because Republicans will do everything in their power to cover it up. In similar news, multiple Trump affiliates have been subpoenaed by the January 6th Commission. Figures like Rudy Giuliani were subpoenaed along with people like Sidney Powell and Jenna Ellis, all members of Trump's legal team. Jenna Ellis once claimed that there was enough evidence to decertify the election in at least 5 states. Rudy Giuliani also began making strange claims that they could overturn the election in the counting of the House of Representatives, all of which makes them of particular interest to the commission. Sidney Powell is of specific importance because she has made ridiculous claims that Dominion voting systems helped overturn the election by changing voting counts, switching records, and all other sorts of malfeasance, which has resulted in a lawsuit being filed by Dominion voting systems against Sidney Powell, a lawsuit which she is likely to lose. And while the subpoenas do have the power of Congress behind them, and these people could refuse and suffer consequences as a result of that, it is also possible that they may claim attorney-client privilege. Many of them were operating as Trump's personal lawyers when they were working with him. If they do claim client-attorney privilege, it could be a long drawn-out fight to get them to testify with very little room to work with. In all likelihood, they will fight any subpoena to the bitter end. However, what this does represent is that members of the committee are increasingly willing to go after bigger names and bigger fish. If that is true, then it could coincide with additional reporting from the New York Times that shows that prosecutors investigating the January 6th attack have begun asking some defendants questions that they hope will establish evidence of a conspiracy by Trump to obstruct Congress. Now, that's going to be a long shot away. Let's be real here. Trump was a former president, so he gets a degree of political and legal protection just by virtue of people deferring to him. However, if you combine the fact that prosecutors are asking about Trump's involvement in January 6th and the fact that the commission is now seeking information from Trump's inner circle, it does appear likely that there will be some form of legal repercussions against people close to Trump. And even if they don't get Trump himself, it is likely that some people around Trump, people who helped organize this kind of rally, people who helped spread this lie, will pay the price for their actions. Rudy Giuliani has already been disbarred in New York. He can no longer practice law there. So it is not unlikely to see some sort of consequence. And even if we don't get Trump on that front, it is worth the effort to put them in their place and make them pay for their attack on our country. In voting news, the Senate has once again killed voting rights legislation. The amended voting bill was killed last Wednesday thanks to the work of Kyrsten Sinema and Joe Manchin, two thorns in the side of the Democratic Party and democracy at large. Senate Majority Leader Chuck Schumer called for the bill to be brought to the floor for a vote, but instead the vote failed along party lines, as Democrats were unable to reach the two-thirds majority ceiling for the bill to go to an official vote. Then Majority Leader Chuck Schumer attempted to change the Senate rules to allow for a simple majority to pass the bill. In response, Senators Manchin and Sinema voted with Republicans against the rule change, effectively preventing the bill from going forward. In response, President Biden acknowledged the defeat but argued that more could be done, saying, "I've been engaged in public policy for a long time, and I don't know many things that could have been done in one fell swoop," he said. Biden then went on to argue that there may be another path for the bill to pass, but did not specify what path that may be. Now, the decision by Sinema and Manchin to vote against the change is yet another example of their consistent obstructionism under the false pretense of protecting bipartisanship. As I noted in my last episode, Sinema and Manchin have received a massive boost in fundraising thanks to their opposition to basic democratic reforms. And it is that fealty to their financial position that is destroying the right to vote right now. Now, it is unlikely that Manchin will be unseated during his next election, which is in 2024. But Sinema, who is up for re-election during that same time, is almost certainly going to be removed by her voters. A Data for Progress poll showed that Sinema is facing significant blowback for her work, with 76% of likely Democratic primary voters firmly disapproving of her performance. Still, that is several years away, and unless Democrats can somehow persuade Manchin and Sinema to change their minds and bring the vote back for another go, Republican attempts to reset the election to their liking will remain the law and will remain unopposed. Americans who will show up to vote will face significant pushback from the Republican restrictions, many of which are completely arbitrary and based on lies in the first place. The fact of the matter is that voting rights as it stands right now are not going to be in a good position come 2022's midterm election. Until we have some sort of reform or some sort of response to this consistent attempt to block voter rights and to block voting rights legislation, our country is going to continue to suffer and our electorate is going to pay the price. In yet another example of conspiracy theorists hurting the political system, anti-vaxxers gathered in the Capitol on Monday with figures such as Robert F. Kennedy Jr. leading the charge towards the Lincoln Memorial. The rally was called Defeat the Mandates, an American Homecoming, and was intended to fight back against what anti-vaxxers see as a government attack on their liberty through vaccine mandates and other restrictions such as mask wearing. In his speech, Robert F. Kennedy Jr. went out of his way to compare the attempts to get rid of misinformation and to support vaccination to the hunting and killing of Anne Frank.
What we're seeing today is what I call turnkey totalitarianism. They are putting in place all of these technological mechanisms for control we've never seen before. It's been the ambition of every totalitarian state from the beginning of mankind to control every aspect of behavior, of conduct, of thought, and to obliterate dissent. None of them have been able to do it. They didn't have the technological capacity. Even in Hitler's Germany, you could cross the Alps into Switzerland. You can hide in an attic like Anne Frank did. I visited in 1962 East Germany with my father and met people who had climbed the wall and escaped. So it was possible. Many died doing it, but it was possible.
In response, the Auschwitz Memorial warned that Kennedy's comments were, quote, a sad symptom of moral and intellectual decay, unquote. Other speakers, such as Del Bigtree, who were at the rally, have also made similar comparisons, putting on the Star of David in order to portray themselves as victims of a sort of quasi-fascism. Now, at a time when there is a massive rise in the attacks on Jewish Americans and anti-Semitism is on the rise globally, it should go without saying that this kind of rhetoric is unacceptable. We would like to believe that this is on the fringe of society, but people like Marjorie Taylor Greene, a member of Congress, has done this as well, and she is one of the largest recipients of donations within the Republican Party today. Now, both Greene and Kennedy have apologized for their comments, but let's not pretend that they actually mean it. If anything, they were upset that it didn't have the desired effect on more people because, at their core, they're demagogues. They sell this idea to people that they're going to be facing a Holocaust while actually downplaying what the Holocaust actually was. They want to scare people endlessly while their fellow Americans pay the price with COVID deaths and infections, and gullible people donate to their noxious work because they're scared. And it's sickening, really. It's a disgusting, twisted way of manipulating the pain of history and the pain of people who died in the Holocaust for your own political agenda. But the fact of the matter is that people like Marjorie Taylor Greene and Robert F. Kennedy Jr., they're going to keep doing it. This isn't even the first time that Kennedy has done this. He's done it before and made similar apologies. So it's not like there's really any incentive on him to stop doing this. And while there's not a lot that can be done to stop him, I can't force him to stop being an anti-Semite or a conspiracy theorist. He has a right to free speech. There can be a way to push back on their messaging, a way to show how crazy and cruel they are by pushing back with our own movement. I don't know what type of movement that would be. Maybe we do similar rallies calling for better health protections, better methods to deal with COVID and things like that. Maybe we have a movement that emphasizes that vaccination is a public good. But unless there is some pushback on what is happening with these kinds of conspiracy theorists who were in our nation's capital just last week, then we are not going to see a serious change in how we handle COVID-19 or in how we deal with any other disease that comes along. There needs to be a change. There needs to be something, anything to push back on this. Otherwise, we're all going to pay the price for their nonsense. Despite the sadness and frustration of that story, I have a great show for you all. We'll be right back after this break, and afterwards we'll talk about Sarah Palin's lawsuit against the New York Times and so much more. In more media news, Sarah Palin is suing the New York Times for defamation after several years of trying to get her day in court. The former governor of Alaska has finally received her chance, with some complications coming in. The suit involves an editorial from the Times which falsely claimed that the shooting of Gabby Giffords and several others was connected to an ad that was released by Sarah Palin's Political Action Committee. The editorial, titled America's Lethal Politics, was corrected the next day by the main New York Times opinion account on Twitter and was quickly updated on the website with a public apology. Palin quickly sued and argued that the Times then editor James Bennett had to know that the claims were false because The Atlantic, another publication that Bennett worked for, had also reported that that claim was incorrect. However, there is no evidence to suggest that Bennett was directly aware or indirectly aware of that reporting. Instead, internal documents revealed by the Times show that Bennett was actually horrified by the revelation that his reporting and his editorial additions were incorrect, and quickly moved to correct the error on record. If anything, the response by Bennett is what is supposed to happen when a newspaper makes a mistake. There is to be a correction as soon as possible. However, Palin argues that the Times showed gross disregard for the truth through their editorial, and that no matter what, it still is a defamation case that needs to be considered because it was a clearly false statement. Now, that's going to be a problem for a variety of reasons. Under current precedent, the law requires that there is some form of actual malice, meaning there has to be reckless disregard or clear evidence that the person was disregarding the truth for something to be considered libel or defamation. And that standard is very high. It's not easy to reach. However, Palin might have a better chance than others would, say like Nicholas Sandmann, because in this case, the New York Times is not under any circumstances saying that their reporting was correct. It wasn't. However, they still might lose. Palin might still lose in this case because the actual malice standard still allows for editorial mistakes, and considering the Times actively went and fixed the reporting after the fact suggests that there was no intention to make a false statement solely for false statements. This editorial also wasn't about Palin herself. She was mentioned in passing. So if anything, this case is more of a representation of to what degree media outlets are allowed to make mistakes in. And from my perspective, when I read about these kinds of cases, when I read about people like Sarah Palin suing the New York Times for this mistake and carrying it out for several years just to get into court, it seems like there's an attempt to go after a symbol rather than to go after a legitimate case. Yes, the New York Times made a false claim about Sarah Palin, and that was completely unacceptable. Bennett himself admitted that it was a mistake and that he was doing it because of rushed time, and he failed to properly cite his sources, and he was wrong. But when it comes to treating this as defamation, there seems to be this element that any mistake on the part of the media is an act of nefarious malice. And that kind of approach is going to be politically powerful for Palin, regardless of whether or not she wins. Now, she's not going to get her day in court for a while, because after she was supposed to go to court, she ended up getting COVID. And there have been multiple recordings of her spreading around showing that even though she's supposed to be quarantining, she's outside just eating out, no problem whatsoever. So the chances are they're not going to be able to determine when it is safe for her to go to court in the future. But what is likely going to happen is that there is going to be a long, messy, and protracted fight that is going to come up in the media for the next couple of weeks, maybe months, discussing the nature of the media. And you can be certain a lot of conservative pundits are going to ride this case, and they're going to use it and say, see, the media is so biased. See, the media only cares about the left, even though this happened several years ago and the people involved aren't even working for the Times anymore. Whatever happens next, one thing is for certain. Sarah Palin's lawsuit and her approach to dealing with the media is representative of a Republican effort to be perpetually in a state of victimhood, no matter the consequences to public discourse. In more criminal news, Trump may yet face charges for his calls to Georgia Secretary of State Brad Raffensperger. Fulton County judges approved a grand jury on Monday to support prosecutor Fani Willis as she conducts her investigation as district attorney. Under its current approval, prosecutors are, quote, authorized to investigate any and all facts and circumstances relating directly or indirectly to alleged violations of the laws of the state of Georgia as set forth in the request of the district attorney referenced here and above. The special purpose grand jury may make recommendations concerning criminal prosecutions as it shall see fit, unquote. While Trump has downplayed the severity of the case, the prosecution appears confident. In an interview with the Associated Press, Willis explained, saying, "I believe in 2022 a decision will be made in that case. I certainly think that in the first half of the year that decisions will be made," unquote. Willis has also shown an inclination to interview Brad Raffensperger, who will almost certainly comply with a subpoena from Willis. In other words, the Georgia Secretary of State's thoughts will be likely out to the public, putting Trump on the spot for his attempts to, quote, find votes. While it is still unlikely that Trump will face charges, this is a case to keep an eye on, especially when it comes to the idea that Trump lost the election in 2020 and how Trump is trying to reframe it as a stolen election. When you put him on spot for saying that the Georgia Secretary of State needs to find him 11,000 votes, as if that's something he could just find and manipulate, that does undermine his argument, and it puts him on the spot in terms of his relationship to the law. And while we won't get to see the full power of this grand jury until May, it should still be in the public consciousness that there are people looking to criminally indict Donald Trump if they find evidence of him committing a crime. And from my perspective at least, it seems like he did. You don't just say to the Georgia Secretary of State, "I need you to find me 11,000 votes so I can win an election and not commit some sort of crime, or at the very least, violate the public trust in some way, shape, or form." And we have him on recording doing just that. For our final story tonight, Justice Stephen Breyer, the oldest member of the bench and one of the more liberal members of the Supreme Court, has officially announced that he is retiring, stepping aside for the Democratic Party and Joseph R. Biden to appoint a new Supreme Court justice, effectively preventing the Republicans from replacing Breyer on the court in a manner that suited them the best. For our final story tonight, Justice Breyer is officially retiring after several decades serving on the nation's highest court. He announced the decision in a press conference with Joe Biden after he sent a letter to the president on the 29th of this month. In doing so, he's effectively giving Biden a chance to make history and ensure that the court does not go further to the right. Biden has promised to put a black woman on the Supreme Court, making him the first president to do so. Though Democrats have not announced their pick for the Supreme Court yet, they will almost certainly do so soon. Still, Republicans are already crying foul, with some arguing that focusing on putting a black woman on the court is an inherently racist thing to do, as if they were only looking for skin color and not the obvious qualifications it takes to be a Supreme Court justice. However, Republicans are actively attempting to appeal to their base in the midterms while ignoring the fact that there has not been any black women in the Supreme Court's entire history. In fact, for the most part, it has been white men that have controlled that court. So Republicans are actively attempting to hide from the facts of why Biden is making that decision. But more than that, the Republicans are raising hell because they lost their chance to stack the court even further to the right. And while the numerical balance of the court hasn't changed, the two oldest members of the court are now conservatives, meaning that while Breyer was the oldest member in the past, he is no longer in the picture for the Republicans to replace, leaving Clarence Thomas and Samuel Alito as the oldest justices, and thus the most likely to be replaced in the future. And while that's going to be years away, and I do not want anybody to just drop dead or anything like that, that is the strategic calculus that is going on here. Republicans realize that their majority on the court in the long term is under threat now that Breyer has been removed. So they're going to raise hell in the hopes that they will hold the Senate, not just for this election, but for the next election and the next election and so on. And while I'm holding back my support about the state of the court because I don't know who they're going to put on there, the change by Breyer makes it much more likely that the court can be moderated or at the very least reclaimed to fix what has been done by this far-right court. And that's something I look forward to, and you should as well. That's all for today's episode. Thanks again for joining me. If you enjoyed the show, please consider checking out the newsletter at progressive-american.com. Thanks again for listening and have a wonderful day.